A renewed push for a right-to-die law in California began when 29-year-old Brittany Maynard, terminally ill with brain cancer, moved from California to Oregon to end her life under that state's Die with Dignity law. But on Monday, Governor Brown signed the End-of-Life Option Act in California. Joining me with details are Dr. Ted Mazur, Speaker of California Medical Association's House of Delegates, and Ken Barnes with Californians Against Assisted Suicide. And Dr. Mazur, the law goes into effect next year. How does it work?
Well, it's very complicated in terms of the process, which was set up to make sure that patients have safeguards against jumping into something or being coerced. Essentially, a patient who is determined to be terminal, 6 months or less expectation of life, would need to go to a physician who is willing to participate in this process and ask orally, twice with at least 15 days in between, to obtain medications prescribed by the physician that would end their life at home under their own hand. They would have to take that themselves, followed by a written request. During that period of time, you would be interviewed by the physician as to your capacity, and there'd have to be witnesses to this. You'd also be interviewed by the physician separate from any witnesses on your own to make sure that you're not feeling undue pressure from a relative, a friend, an insurance company, economics, etc. At which point the physician could then prescribe, and you would take that home and use that at home at such time as you felt that you needed to, or you could revoke and not use it. The
patient themselves takes this. Now, you're touching on some of the safeguards that are in place for the patients and physicians. Ken, do you think these safeguards help make this more acceptable?
Well, no, because the safeguards really focus on protecting physicians from it. What you can't protect against is implicit pressure from families, pressure from insurance companies for cost containment, and pressure from inside a person who's worried about how this is impacting their family.
And Governor Brown said he had quite a bit of struggle with this. He admittedly making this, deciding about this bill. And he said ultimately he needed to decide if the state should continue to make it a crime for a dying person to end their life. Ultimately, he decided, no, it shouldn't be a crime. Do you think that's the central issue with this bill?
No, I think the central issue is how he finished his statement, which he talked about himself and what he would want to do at the end of life. And really that kind of covers everything. He's a very wealthy, well-connected, well-educated man, and it is a personal choice for persons like that. It's not that choice if you're a high-cost, low-income patient, a disabled person, or someone that doesn't have the same access to care.
Now, Dr. Mazur, respond to that.
I'd have to really say otherwise. The concept here that this is only going to affect the low income is just really unfair. This is for all population. There are safeguards. You know, we have an expansion to access to care, not as good as it ought to be for the poor in the Medi-Cal program. That could certainly be improved. But when we talk about why the governor made this decision, the governor didn't do it for himself. He said, I don't know what I would do in this position, but I don't know that I can take that option away from other people. It wasn't for the wealthy by any means. And the protections that are put in here, the concept of coercion by insurance companies is very well prohibited in here. The concept of coercion by family members is prohibited, in fact, as a felony crime. There are limits to what we can do to stop people from doing what they shouldn't do, and you make it illegal to do that. A lot of protections were put in here, not for physicians. The main protection for physicians was if a physician doesn't want to participate in this, they're not held liable for not participating. The bulk of the changes from the original writing of this were to protect patients.
Sure. And Ken, let me ask you this then about that. So if these safeguards are in place, what else would you rather see if you would rather not see this go forward? What else could help people in these terrible situations?
No, it's an excellent question, because that at the core of everything is, what do we do for people at the end of life who are suffering in pain? And I really believe, and all of us believe in the coalition, that we should put a extreme focus and resources into palliative care to alleviate pain and suffering, hospice care for places for families to go to be with their loved ones at the end of life, and not just kill them off. I mean, we've got to focus on how do we help persons at the end of life? How do we ease their suffering? This is a major issue, and that's not being talked about.
Well, is it being talked about is my question to Dr. Mazur, because I know the California Medical Association is going to be talking about this subject in its upcoming meeting next week.
Right. We are still, as physicians, somewhat divided on whether people want this to be a physician role or not. That will be talked about, not this law in particular, but whether physicians would participate in enacting this and working with their patients. We vetted that very carefully when the Medical Association went from an opposed position for 30 years to a neutral position and let this be a physician-patient decision without you can't. And now we're going to be discussing, again, the physician's role in this process.
All right, much more to discuss on this later. Dr. Ted Mazur and Ken Barnes, thank you so much.
Thank you.